My name is Lucy Sandell, and I'm thrilled that you're joining us today for a webinar entitled Not Patently Obvious, How the U.S. Patent System Works. Our presenter today is alumnus Ahsan Sheikh. Ahsan is a graduate of the law school and Intellectual Asset Magazine has identified Ahsan as a world-leading patent professional, stating that his clever application of analytics enables him to identify which arguments are most effective before different examiners, making his advice gold dust to software companies. I love that quote. It's my pleasure to welcome and hand over the controls to Ahsan.
Thank you, Lucy. Good afternoon, or good morning, or good evening to everyone here. As Lucy mentioned, I'm a graduate of the law school, class of 2005. While I was there, I had the good fortune of studying under a lot of great professors, including a future president, as well as a very famous judge, Judge Posner, the future president, of course, being Barack Obama. So I had a great experience at the University of Chicago. It has really colored my career so far. In the last 12 years, my career is focused on patents, and particularly software patents. I work at a firm named McDermott, Will & Emery. For those of you not in law, you'll probably hear that as just a bunch of names like most law firms are. But for context, McDermott, Will & Emery is one of the largest law firms in the world. They have offices everywhere, and I lead our software patent practice out of Chicago, which is where I am today, as well as the Bay Area. Most of my work revolves around software patents. So if you have touched any computer type device, whether it's a laptop, desktop, your mobile phone, or anything in the last 10 years, my team has probably worked on a patent that you've used. So apps, software, computer hardware, networking, everything, all of that is patentable, and parts of it have been patented, and I'll talk a little bit about that at the very end. I also wanted to mention that I welcome any questions during the presentation. If you have them, I believe they're going to go to Lucy, and she can ask me during the presentation. Well, I'll also leave time at the end for questions as well. So starting with my presentation, what I'll talk about today, I'm going to go from a very high level about what intellectual property is, and then boil it down at the very end to a very, very particular case example. And so what the agenda generally is, I'll start with discussing whether or not ideas should be a property right, or should they instead be free. And then moving forward with the fact that if they are a right that people should have, they are a property right that people should be able to control their ideas or expressions, then with that in mind, I'll discuss the different forms of intellectual property. People often confuse trademark, patent, and copyright and what they do, so I'll distinguish that a little bit. Then follow that with a history of what patent rights and intellectual property rights have been, and then going down a little bit more detailed, discuss the requirements in the U.S. patent system for obtaining a patent as a implementation of the history of patent rights. Talk about some famous and infamous U.S. patents that apparently have met the requirements to get a patent, and then talk about a controversial question, at least within patents, which is, does the U.S. patent system work to promote the advancement of technology? A lot of arguments today say that maybe it doesn't in certain areas like software, but it does in pharmaceuticals, and I'll talk a little bit about that. And then finally, I'll discuss my area of focus that I spend pretty much my entire day in the last 12 years doing, which is U.S. software patents in the U.S. Companies like the ones that you use on your phone. And I'm going to be a little bit reticent on company names, just because as an attorney, I generally cannot freely discuss company names or comment on patents. So you might notice that as I start talking about patents. So beginning with, should ideas be a property right? There are three main arguments as to why ideas should be a property right. And what I mean by being a property right is, do you have the right to your idea such that you can stop or control other people from using it? And so the first major theory behind this is a major approach to saying why proper ideas should be a property right are by a group called the personality theorists, and they say that your intellectual property is an extension of your individual personality. And what that means is, and Hegel is probably the most famous philosopher who says this, is that individuals have a moral claim to their own talents, feelings, character traits, and experiences. So that that probably makes a little bit more sense, that you have a claim to your own feelings, you have a claim to your own experiences, and to your own character traits. That kind of naturally makes sense. So as an extension of that, you should then have control over the intellectual objects that extend from your talents, which you should have control over. And so under this personality argument, you therefore should have a right over an extension of your individual self, which would be your intellectual property, such as an idea you came up with. The second major argument for intellectual property, or these are all alternative arguments, is the utilitarian argument, and this forms the basis of the U.S. patent system. It's the idea that people need an incentive in order to innovate, which, in other words, if you are going to spend a lot of time coming up with an idea and working on that idea, then you should have some incentive for doing so. And the incentive in the U.S. is that you're given a monopoly over that idea. Whereas, let's say if there was no incentive for working on or developing an idea, then people wouldn't proceed with it. This is, again, I touched upon this earlier, this is a distinction that's made between software patents and pharmaceutical patents. And they say, an argument made today is that people do not need an incentive, at least a monopoly incentive under the US patent system, in order to invent software. So if you're going to release an app, your incentive is going to be the adoption of your app or the money you get from releasing an app, and that's sufficient for you. You don't need to have a monopoly on the app so that other people can't copy it. Whereas for the pharmaceutical industry, an incentive, monopoly incentive is important, because as soon as you release a drug and you've worked on this chemical formulation and you've tested it and you made sure it's safe, as soon as it's released to the public, anyone who has access to a lab can recreate the drug. And unless you have an enforcement right or a monopoly to stop other people from copying that drug, then you're going to lose all of your investment in it, because as soon as you release it, another company is going to copy it and release the same drug at much, much less cost. And so that's the utilitarian argument. The final argument is the Lockean argument, which is that rights are justified in relation to their labor and merit. And so in other words, individuals are entitled to control the fruits of their labor. So if you work hard on something, then you have a right to what you've worked hard on. So those are the three main reasons why people argue ideas should be a property right. There are four general arguments made why ideas should not be a property right. The first is generally that information is not the kind of thing that can be owned, as opposed to like physical objects. So I think of my 3-year-old son, where as soon as he touches a toy car or a transformer, that we went to visit my parents' house last weekend for Thanksgiving. I had this transformer toy my mom has kept for 30 years. And as soon as he touched it, he said, "It's mine," which was flooring to me, because I've, I guess, been the owner of it for 30 years. But he claims that it's his to own, and that would be the type of argument that something that's a tangible object is property and can be owned, whereas information is not tangible and cannot be owned. The second argument is that information is non-rivalrous. What that means more simply is that you can use information in a way that it doesn't stop other people from using it. So if you play an MP3, someone else can download an MP3 and play it at the same time as you, and it doesn't take away from your playing of the MP3. Information can be reproduced. And this probably unintentionally underlies why information or piracy is so common, is that people feel that, well, I'm going to download music, and it's illegal, but I'm going to download it anyway, because they feel that, well, I'm not taking away from anyone else downloading it, and it's easy, and so if I'm not taking away from anyone else to download it, and so I'll download it and play it myself. And this falls under the argument that information is non-rivalrous. The third is a bit of a strange one, I have to admit, when I read this. Information wants to be free. And so the argument is that information is alive and thus has a claim to be free. And I have to read from my notes on this one, because I kind of find it a bit strange. So the argument is made that information objects are life forms in every respect but a basis in the carbon atom. So they are alive except that they are not based in carbon. Information self-reproduces, it interacts with its surroundings and adapts to it, it mutates, and it persists. So you can imagine that, and this is going to be a bit of a stretch for me, but if you have an idea or a story, that the story will persist in that it was told once and can likely be told again. It will adapt to its surroundings, so it might be acculturated into a different culture, like different stories of unrequited love, like Romeo and Juliet in Western and Hellenistic culture, or Layla and Majnun in Middle Eastern culture. So these are basic stories that adapt to the surroundings around them, and they persist in that these stories kind of go on and are repeated in different ways. Finally, the fourth argument against intellectual property is that intellectual property contradicts free speech. This would be something that is more popular in governments that promote free speech like ours, in that if you have a system in which there's a commitment to freedom of thought and freedom of speech, yet you restrict ideas through a trade secret, for example, so you keep an idea very secret so no one has access to it, those underlying principles kind of contradict one another. And so that's an argument against intellectual property. So those are the for and against arguments for intellectual property. I will take a brief break to see if there are any questions on any of these arguments.
There are no questions yet,
Okay.
but well, there are no questions from the participants, but there's a question from me, if you don't mind taking it.
Okay, sure, of course.
You were talking about downloading music, but would that be considered patent law or trademark or both?
So the most directly, it's copyright infringement, and I'm going to get into this a little bit later, but music is copyrighted. So copyright is an exact expression of an idea. So the notes and lyrics and sounds that create a song, those music falls under copyright. So if you illegally reenact or perform music under U.S. copyright law, then that's considered copyright infringement. So, for example, I don't know the specific rule on this, but you can't rent a movie and then display it in a movie theater. Like there are some limitations on the reenactment of a copyrighted song or movie or other copyrighted work. So there are limitations on how songs or music are played or reproduced.
Great, thanks.
That's actually a good lead-in to my next slide, which is the difference in which I should have probably switched to when you asked me. The four different types of intellectual property. So we've talked about arguments as to why ideas should be claimed as a property right, which we call intellectual property. So arguments for intellectual property and arguments against intellectual property. Moving forward with the acceptance that intellectual property does exist, I'll now distinguish the four main different types of intellectual property that are out there. The first is probably the most common. It's copyright. Copyright applies to songs, music, books, software code, maps. Copyright covers an exact or an expression of an idea or work. So I mentioned earlier the example of a story of unrequited love. Excuse me. So the idea of unrequited or jilted lovers that's an underlying idea. You cannot copyright the idea of unrequited love, but you can copyright the expression of unrequited love between two lovers. And so Shakespeare's story of Romeo and Juliet, that is an expression of the underlying idea. And so Romeo and Juliet at some point was copyrighted. It's not anymore because under U.S. copyright law, copyright applies to the lifetime of an author plus 75 years. That is a specific statute. That's not necessarily anything based in natural law or anything like that. But you can imagine Mickey Mouse is copyrighted because that's an expression of you can't copyright a mouse the abstract idea or the idea of a mouse, but you can copyright the expression or shape of a mouse as it has been visualized. And so Disney has the copyright on Mickey Mouse. And in fact, I think the reason why the U.S. copyright law is the lifetime of an author plus 75 years is because the copyright on Mickey Mouse was going to expire when Walt Disney died. And this is not my area, but I think I remember reading something about this. And so Disney needed to extend it. And so they petitioned with, I'm sure, other people for good reasons, I'm sure, that the copyright should be extended beyond the lifetime of an author. And so that's why Mickey Mouse is copyrighted for 75 years after the death of Walt Disney. So that's copyright law: music, movies, maps, computer software code. The second type of intellectual property, and this tends to be the most powerful or strongest form of intellectual property protection, is patents. So I described this dichotomy between underlying idea and expression of the idea. Copyright covers the expression of the idea. A patent covers the underlying idea itself. And so in legal terms, patents cover processes, machines, articles of manufacture, or compositions of matter. What that means is they cover physical objects. They basically cover physical objects or processes in everyday terminology. The time period for this is 20 years. It was 18 years before, but if you're able to get a patent on an idea or machine or method, it lasts for 20 years. And as an example of this, you can imagine, just imagine that, let's see, the underlying idea of, in an app, let's go to software. This is a hypothetical example, but if the first person who invented a ride-sharing app probably could have patented ride-sharing. So ride-sharing is commonly now Uber and Lyft. There were companies before, but hypothetically, whoever first came up with the underlying idea of ride-sharing, if they had applied for a patent, they might have been able to get a patent on it if they were able to meet the requirements for it. That would have been patent law's application to the software app for ride-sharing. Where copyright would have come in would have been the person, you take that idea of ride-sharing and then you have to code it on a computer using software code. Then that exact software code, so the letters and numbers that are coded into a very long computer program, those would have been covered by copyright. The weakness in copyright is if someone would have altered some of the lines of code in that ride-sharing app and there was no patent on it, then the person who had invented ride-sharing would not have been able to stop the other person from ripping off the idea by simply changing a couple of lines of source code. But if a person had patented ride-sharing and someone had just changed a couple of lines of source code on the copyright for ride-sharing, the person with the patent would have been able to enforce their patent and stop the other person from reproducing the idea and launching a competing app. That's kind of a glimpse of why patents are so high value, particularly in the software industry. The third type of intellectual property is trade secret. The most famous example of a trade secret is the Coke formula. I think only 2 or 3 people know what it is. A trade secret is in some ways the opposite of a patent. The bargain behind patents for the U.S. government and why the U.S. government grants a monopoly is that the U.S. gives you a 20-year monopoly on your idea if you were willing to share with the rest of the public the best way of performing your idea. So if it was a ride-sharing app, then you share in your patent filing the best way to code ride-sharing, to come up with algorithms on who's going to pick you up, how you match your driver to a rider, the route they're going to get to their destination, pricing. You'd have to disclose the best methods, best forms of doing all of that. And in that bargain of disclosing the best methods of how to perform an invention, the U.S. grants you a 20-year monopoly. The flip is trade secret. You don't share anything with the public. In fact, you're obligated to keep it as a secret and show that you're keeping it as a secret. And if you do, the government will help enforce your trade secret by implementing different legal punishments for someone who illegally steals the trade secret. So if someone were to illegally steal the Coke formula, there would be increased punishments for them under laws as opposed to just stealing something that was not considered or attempted to be enforced as a trade secret. Finally, the fourth one is trademark. This is also kind of confused. People use the word trademark, patent, and copyright in different ways. Going to the Coke example, a trademark covers the name, symbol, or device adopted by a manufacturer to identify her goods or his goods to distinguish them from goods produced by others. So the Coke symbol, Coca-Cola, the way it's written in script, the colors that are used, red and white, even the shape of the bottle, I think those are all trademarked because they identify a way in which the product is sold. So putting this all together, let me give you an example of one thing that would have a patent, a copyright, and a trademark on it. Let's see. That might be, okay, so it's going to have to be an app because that's my area. But since we were talking about ride sharing, let's say I do know that Uber has patents. I don't know what they're on, but Uber probably has a patent on the matching algorithm, or one version of a matching algorithm for how to match drivers to riders. So if you imagine the app on your phone, it's covered by a patent with the underlying algorithm that's is used to match you to a driver. It's covered by a trademark because the black and white coloring of the app and the way that Uber is written, and probably the Uber symbol, that circular shape, that's covered by trademark. And finally, copyright, that the app itself is written in source code, and source code, like any other expression or written work or music, automatically obtains the copyright once it's created. And let me make that distinguish a point here. So copyrights are granted to you automatically, but there's a benefit in registering your copyright with the government. Patents you have to apply for and prove you deserve a patent. Similarly, with trademarks, you have to apply for and prove you deserve the right to mark that, to trademark your brand name or color, shape. Trademarks are much easier to prove than patents. And then finally, trade secrets are kind of after the fact. If someone steals your trade secret, you need to show in a court case after the fact that you had protocols in place to keep it a secret. So those are the four major types. Those are the four primary forms of intellectual property. All right. So so now that we've discussed intellectual property, why there are arguments it should exist, and the different types there are, let me tell you a little bit about the history of intellectual property rights. So this covers everything, not just patents, but I'll focus on patents as well. The first example, and this is to the right of your screen, of any kind of intellectual property being recorded in history was in 500 BCE, where chefs in Greece were granted year-long monopolies for creating certain culinary delights. So this would most likely closely correlate to copyrights here. So a copyright on a recipe, you can patent a recipe, but it's much more difficult. So this would kind of be copyrights were granted on recipes in 500 BCE. And then the first case of a copyright infringement occurred somewhere between 257 and 180 BCE, which was the life of this person, Vitruvius, also in Greece, who exposed false poets during a contest because he recognized that poetry that was being recited by certain poets the poetry was copied by other poets who had actually written them, and so he'd exposed them, and then they were later convicted and disgraced for stealing it. So that would be considered copyright infringement. We then get into patents almost 1,500 years later in Florence, by the Republic of Florence granting an architect. It's the only patent that the Republic of Florence had ever granted. I'm not sure why that is or if it was ever enforced, but it was the patent law in Florence provided in its grant a recognition that Filippo or any other author or inventor later on who might get a patent had a right to their intellectual efforts under the patent law, and that others were restricted from exercising whatever the effort was. This was cultivated much better, in much more detail, 53 years later in 1474 in nearby Venice, in the Statute of the Venetian Republic, that in many ways mirrors modern patent law and its incentives, where inventors were granted an incentive mechanism. So this is the utilitarian model. And then they were also given compensation for infringement. and they were given a term limit on inventors' rights. So these are three really key aspects of modern patent law that first appeared, at least in the recorded history that we have access to, in 1474. So the basis of our patent law and additionally our copyright law comes from the U.S. Constitution in Article 1, Section 8, Clause 8. And again, it follows the utilitarian model, as you can see by the large text here and the language before the quote, which is in order to promote the progress of science and useful arts. So this is the incentive that for the, in order to, the bargain that is struck with any inventor is, sorry, this is not the incentive. This is the purpose behind the incentive. For the purpose of promoting the progress of science and the useful arts, an incentive is granted to inventors, and the incentive is securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So that is the incentive for copyright and patents in order for the bargain of promoting the for the goal of promoting science and useful arts. So that's the contract, so to speak, that's struck with under the U.S. Constitution, is that a monopoly is granted if you're willing to a monopoly is granted in order to inventors and authors in order to promote the progress of science and useful arts. Okay, so that's patents. So that's the U.S. Constitution law. Now I'm going to focus on patents and limit my discussion to patents moving forward. So you might have had family members, I know I do, that say I should get a patent on that, or you might have told people after you hear a really good idea saying you should get a patent on that. That's probably the most use that I have to my family members, or that with my legal career, is that my family members often ask me about whether or not they should apply for a patent on something. How do you respond to I should get a patent on that? There are four main requirements under U.S. patent law that you need to show to the U.S. Patent Office in order to obtain a patent. The first one is that the idea must be patentable subject matter. So the idea itself must be something that is eligible for patenting. And I can describe this in a way by telling you what's not eligible for patenting. So you cannot patent a law of nature. So if you were to discover that the law of gravity existed, then you cannot patent the law of gravity. If you were to discover that a plant existed, you were to go in the Amazon and you found a plant that if you were to eat its leaf, it would cure cancer, you cannot patent that because under U.S. patent law, that is excluded from being eligible for patenting. And then finally, abstract ideas like the concept of selling goods. You cannot patent the concept of selling goods in the marketplace. The abstract ideas are particularly relevant to me in software patents because there was a Supreme Court ruling 3 years ago that attempted to define what abstract ideas were relative to patents, and it did not do so in an effective way. And because of that ruling, it has been much more difficult to get software patents. And as a result of that, a lot of the companies that have apps that you see on your phone or on your computer, it's much more difficult for them to get software patents now. And so that's where this first requirement has become a real onerous burden on applicants now in a way that prior to 2014, number one was pretty much assumed. Now number one is really hard to prove for software patents. Number two, the second requirement is that your idea must be novel, so it cannot have been done exactly before. So if you were to invent a 5-wheeled bike and no one had ever invented a 5-wheeled bike before, then your bike would be considered novel because it has not ever been available to the public that we've seen. It would not, however, meet the third requirement, which is that your idea be non-obvious. So not only does your idea have to be novel, which is point 2, but it has to be a non-obvious variation of something that already exists. So a 5-wheeled bike, it could be argued, probably successfully, is an obvious variation of a 4-wheeled bike, which you might see at the beach, or a 3-wheeled bike. And it would be argued that adding an additional wheel onto a bike is obvious to do so. So you must prove, and this used to be the hardest thing to prove in order to get a patent, and in some ways, outside of the software industry, it is still the hardest thing to prove. You have to show that your idea is a non-obvious variation of what technology already exists. And when I say technology that already exists, this is something that I think for people who are not involved with the patent system, this is a little bit difficult to grasp. So there are a lot of ideas that have been submitted to the patent office that were never put into production. So if you come up with the latest, let's say you come up with a drone to, a way to, like a phone case that can turn into a drone that you can throw your phone up and it flies and it can take a selfie of you and fly back to you. Let's say that sounds like a wonderful idea. It may be that someone submitted a patent application for that idea to the patent office, but they never manufactured it. So you've never heard of it before, but it has been submitted and has been invented or otherwise made available to the public before in point two. And so even if you had a variation on what was submitted to the patent office before, it would have to be a non-obvious variation to what was submitted before. And that's generally why it's difficult to get a patent, because there are a lot of ideas there that have been submitted to the patent office that most of the world doesn't know about because they don't deal with the patent office database. And you, as a patent attorney, we have to argue those prior submissions to the patent office are brought in front of us as patent attorneys, and we have to argue why for our clients deserve a patent in view of those things that have already been submitted, as well as what you already know about and what exists in the marketplace. So that's point three, to prove that your idea is a non-obvious variation of all the things that already exist or have been submitted. And the fourth point is to prove your idea is useful. This is really effectively a checkbox. I have, in my 12 years, never come across a rejection from the patent office of an idea not being useful, but it is a requirement for the patent office. I'll take another break to see if there are any questions on any of the points I've discussed.
Yes, there certainly are. This one is a bit long, so and that's not a problem. I just want to let you know so you don't start answering the question before I'm done. If these patent laws and ideas on property rights are U.S.-based, how are they applied internationally? Are international patents considered concrete in the U.S.? And can people in the U.S. steal an international patent and claim it as their own if the country's patent laws are not as concrete?
So I'll give the short answer and then the long answer. U.S. patent rights only apply in the U.S. You have to apply for patents in other countries in order to obtain patent coverage there. That's the short answer. I'll detail it further. And then the short answer to the second question is no. If someone invented something else in another country, then ideally, then you cannot patent it in the U.S. because it already exists. It's already available to the public under point two here. So it's not just available to the U.S. public. It's available to the public and the public worldwide. To detail that out a little bit further, patents are a right that you have to choose to enforce. So you can invent something and never patent it, and therefore you don't have the right to stop other people from doing something. Patents give you the right to stop other people from making, using, or selling your idea. You don't have to, even if you get a patent, you don't have to you don't have to enforce it. So if you have a patent on something, you don't have to stop other people from making, using, or selling what you've patented. You can, and so that's what the right patents give you. But your right to do that only exists in the U.S. under a U.S. patent. You'd have to apply in Australia in order to enforce a right there and prove to their patent office that you deserve a patent. You have to prove to each of these patent offices that you deserve a patent, and they often do look to one another. So Australia might look to what the outcome was in the U.S. and often does and grant a patent more easily that way. And it's a pretty expensive process to patent in foreign countries. The biggest companies in the world usually don't file patents everywhere. They're selected themselves on where they file because it is expensive to pursue patents everywhere in the world. The second question was, the longer answer, if an idea is available to the public, the burden is on the U.S. Patent Office to find that the idea existed before, whether it existed in the U.S. or outside the U.S. If they find it, and once they find it, they will often reject your application for a patent based on that idea, and then you have to argue why you deserve it, maybe by amending your patent and claiming less in order to overcome the idea. Oftentimes, sometimes the Patent Office doesn't find existing prior art, as it's called, or existing technology, and a patent is granted, and that often is the reason why you see some questionable or weak patents out there, is because the Patent Office wasn't able to conduct an effective search, and those patents can later be invalidated through the court system.
Thank you. What are typical damages for copyright, patent, or trademark cases?
That's a tough one. So that is, I'll preface this with the short answer saying I don't know. It's the area of law I help in is to help people get patents. The area of law that's discussed here is called patent litigation. It's once there's a challenge to a patent copyright. There's a very particular formula that's used in the U.S. for each of those. For patents, it's a percentage of whatever profit was gained by the use of that patented technology in the product. There was a famous case recently, I think it was between Google, I think it was Qualcomm and someone else, and maybe like Apple or some major device manufacturers, where it was argued that the patented feature, I think it was for FaceTime, for video conferencing, so it wasn't Qualcomm, it was someone that said some company was infringing the video conferencing feature, and that was shown, I think, that the company did infringe a patent on it, and so the court had to figure out how much of the sales of that physical device was due to the video conferencing feature, and then based on that percentage of what percentage of it was, they come up with some sort of calculation. But it's a percentage of whatever the profits were.
Okay, great, because that answers the next question, because the next question was, if Uber sues, can they set their damage request? But it's based on a percentage of how much was made.
Yes, yep, and you can request an amount of damages. You have to provide a reason for it. So I'm sure a company, this is probably the lawsuit between Uber and Waymo right now. That's probably one of the more famous patent litigations going on right now on self-driving cars. So if one company is found, I think Waymo, aka Google, is suing Uber for stealing technology. I think if it's found that Uber stole patented or infringed patented technology of Waymo, then Waymo will have an opportunity to set the damages and say, these are the damages, these are the amount of damage that happened to us, and this is how much we deserve. And then Uber would counter with it, and then the court would decide what's fair.
Gotcha. Thanks for clarifying.
I'm guessing there are no other questions?
Oh, yes, sorry. No other questions.
Okay. So these are the 4 requirements for obtaining a patent in the U.S. I will talk at a high level about some of the more famous patents that are out there. These would be arguments for the patent system, generally. I've looked through many different listings of what some of the most important patents in U.S. history have been, and I think these are among the top. The first is for the electric motor, and the argument could be made here that this would go under the incentive argument. I think that if a person would need to be incentivized to develop the electric motor in order to release it to the public with the guarantee that they had the right to, that no one else would copy their motor and sell it immediately after them. Because as soon as you expose this to the public, you build a motor and you sell it, someone else can deconstruct it and rebuild it again, unlike the trade secret. So the Coke formula, you can't figure out by drinking Coke what the formula is. Something like an electric motor, that you need to incentivize someone to build it first and get a patent on it. The same goes with the ice machine invented in 1851. The telephone in 1876 by Alexander Graham Bell. This was an improvement on the telegraph system, so he built it off of the telegraph system. Fourth, the light bulb. Was the light bulb Bell? I forgot. I forgot which one was Bell. Might have been both, actually. And then the integrated circuit, I wanted to pick something more recent. In the integrated circuit, there was some controversy around who invented it, but it was patented in 1959. So each of these are these patents are great examples of major leaps of innovation in technology that at the time really promoted the science. I think it was useful arts as said in the Constitution. These really pushed the ball forward on technology, and by exposing to the public these inventions at those times, it allowed other people to build off of those inventions. The picture here is of the light bulb. Oh, that reminds me. The other point I wanted to make is, so these are all major improvements in existing technology. In order to get a patent on something, generally speaking, it need only be a minor improvement to existing technology. So you don't need to invent the hoverboard from Back to the Future. Like, that's not the standard by which you get a patent on something. In fact, it's way lower. It's usually a modest improvement to existing technology. And that's an argument many people have against the patent system, is they say that if you can get a patent on a modest improvement to existing technology, then you're going to create what's called a patent thicket. So there are going to be way too many patents out there that a company wanting to innovate will have to worry about, that minor improvements have all been patented, and that anyone who owns those patents can come out and assert those patents against a young company and cause that company to really be tied down and not be able to innovate. And that's a valid argument. It's one that I think is a very strong one. Now, those were 5 examples that people would consider very strong and great patents. These are 4 examples of patents that generally have been identified as being questionable or controversial. The first is for the iPad. As you can see on the right, it's titled Portable Display Device. This was famously used in the Samsung versus Apple lawsuit. And the patent is a design patent, which is designated, if you see on the second line here, the patent number is D670286. There are different types of patents, which I forgot to mention. I'll describe them in a second. But a design patent covers an ornamental design, and this one covered rounded edges on an electronic device. That's about the extent of knowledge I have, and you can see why someone might argue that a patent is not deserved on this. But Samsung, as you all probably know, who've seen Samsung devices, I think they still have rounded edges on their devices. The second is, and the second and third, I think, were done by patent attorneys who were attempting to show how broken the patent system is. So number 2 is for a synthetic stick used as an animal toy, so it covers effectively a synthetically made stick as opposed to a branch that's naturally made, and that's it. You can understand why that would be questionable. The third is titled Exercising a Cat, and it covers the method of exercising your cat using a laser pointer. So using a laser pointer causing, I think, a cat to follow the light that's projected from a laser pointer. This one I know was done to show how the patent system is broken and needs to be fixed. And what I mean by that is the patent system, I think even patent attorneys agree, could always use improvement. And one of the areas where improvement can be had is providing more resources so that the examiners at the patent office can have more time and better computer resources to search for existing technology in order to better reject applications for patents that should not be granted. The fourth is the one-click shopping patent. This was a famous example that made in the press, I think around late 2000s. It's Amazon's one-click, so one-click buy. Amazon obtained a patent on it in 1999. You know, hindsight is 2020. Now that seems really obvious. In 1999, it probably didn't seem that obvious to go online and just click once and buy something and have it shipped. I mean, even now, a lot of people hesitate to, when they order something, they like double check their order, they make sure all the stuff is appropriate in the cart, where is it shipping to and all that. In 1999, you can imagine most people with their dial-ups were really questioning whether or not they were going to buy something. It was probably like a 10-step process then, who knows. But that's the one-click patent. I think the one-click patent is generally now invalid, but I'm not sure. I mentioned that I was going to talk about the different types of patents. There are three. The most common patent is called a utility patent. That covers software. It covers physical objects. It covers pretty much everything you would generally consider a patentable. There are design patents, which cover ornamental designs, like what you see here on the right. They are not allowed to cover any functionality. So utility patents, the most common, popular kind, do cover the functionality. So I mentioned the ride-sharing app hypothetical. That would cover functionality of creating a ride-sharing app. Design patents simply covers design. They're most commonly used for tire treads, for ornamental design. The functionality of a tire tread would be separate. It would be a utility patent. And then finally, there's something called a plant patent, which is any new variety of plant. And I'll be honest, I've never come across a plant patent in my life, so I really wouldn't be able to comment on that. But most patents are all utility patents. And I'll stop for questions again.
How much does it cost to apply for a patent? Does it vary depending on what kind of patent you're asking for?
So the patent office charges for a utility patent. So that I should be more detailed. So there's something called a provisional patent. It's basically a temporary filing at the patent office that lasts a year that says, I've come up with an idea, but I need more time to develop it. That costs, I think, $200 to file, but the provisional patent expires after a year and is never examined. The traditional patent application is for the utility patent. For that, the patent office charges a micro entity, so that's a company of 2 or less people. I think it charges $450. For a company of 500 or less people, the patent office charges $900, and for a company of 500 or more people, it's $1,800. So those are the patent office fees. Patent attorneys like myself who draft the patent application, what we effectively do is we are high-tech translators. I have a computer science background. I worked at Cisco Systems. I did a computer science degree at Berkeley. I meet with software developers. They talk to me in software talk, so they show me their source code. I translate their software speak into the legalese that is best suited for the companies that those software engineers work at, for those companies to obtain a patent on their technology. So patent attorneys are generally helpful. They're not necessary in order to apply for a patent. You can apply for a patent yourself, so you wouldn't pay a patent attorney. But if you pay a patent attorney, the price for preparing a patent application runs anywhere from $3,000 to $15,000, depending on the experience level, the size of the firm, and a whole bunch of other stuff. And I will say, and this I'm biased because I work at a large law firm, but in my experience, you usually get what you pay for. The analogy I use is it's like the 3 little pigs. If you build a patent with sticks, I just read this to my son. So if you build it with hay, then it's going to be easy to blow that patent down in litigation. If you build it with sticks, you pay a little bit more, then it's hard. It's still going to blow down, maybe a little bit more difficult. But if you build it with bricks, so you hire a very experienced patent attorney. They don't have to come from a big firm, and that doesn't necessarily mean you pay them a lot. But the amount you pay is generally equated to the experience, as with the entire legal field. The better quality patent attorney you have, the more likely your patent is to be enforceable if it's challenged in court, and that's when the mettle of your patent is truly tested, is when it's litigated in court.
Great. Another question. What part of government is the patent office under?
It's under the executive branch. And in fact, it is a big moneymaker for the government. The patent office is incredibly profitable, and it's to the detriment of the patent office, and this happens, I think, under a lot of different administrations, that their profits end up going to fund other parts of the government, whereas if more of their money were used to fund their own resources, we would probably have a higher quality patent system. But you can imagine, and I'll go to my next slide here, the top companies that are filing patents, if they're paying $2,000 a pop for each patent, and those are 8,000 patents granted in 2016 out of probably 3 or 4 times as many that were filed for, that's a lot of money the U.S. Patent Office is making. So it's under the executive branch, and they make a lot of money.
So they're scooping it up. um, Next question is, what is the most memorable patent you've ever worked with and why?
Huh. I'm trying to see. The only patents I could talk about are patents that have issued, because those are ones that are now public. Let's see. I remember working on a patent for a moist towelette, and that's memorable to me just because it's so different than my background. That was when I was starting out as an associate, and those are like baby wipes to wipe a baby's bottom when they wet their diaper. I've done one for a laser weapon, which was really cool. It sounds like it's something out of Star Wars, but it was basically a projected laser that shot out of a satellite dish that could shoot down planes. So that was pretty cool. Those actually, if you go online and YouTube it, you can see these. They don't work like Star Wars. You actually have to focus it on the plane for a long time, like a drone for, I think, 45 to 50 seconds in order to heat it up enough. But that was really cool. And then I've worked on stuff in software, which I personally find fascinating because as an undergrad at Berkeley, when I did my computer science degree, there was a computer theory class where each assignment, literally, I would stare at the wall for an hour to solve the riddle, so to speak, of what the code was to decipher a computer problem. And I now get to work with software engineers from the coolest tech companies in the world who solve these problems every day, and I get to hear how they solve them. And those to me are really cool because I feel like I'm there with them solving it, and then I hear what they've done. It's just really cool. So I enjoy the software stuff a lot.
Great. Thanks so much. That was a great.
All right, so these are the top patent owners as of that received patents in 2016. So IBM is always pretty much number one. They always get the most new patents each year. And then you can see on this list, only numbers 3 and 7 are not directly in the computer technology space. So Canon and GE, they have other industries and they have other businesses that are not computer focused. But 8 out of the 10 are in computers, and the computer industry is by far the most common area to file a patent in, is generally the hardest to get, and is probably the best space to be an innovator in even these days. I mean, everything seems to relate to computers and software, even if your industry specifically is not in computer or software. The latest innovations, or the people who are getting ahead in most of the non-computer or software industries, are using computer or software to get ahead. So that seems to be the most popular. All right, so there's this question. So we talked about why philosophically a person has a right, intellectual property right to their ideas, or they don't. This question is a little bit different. So does our system in the U.S., does our patent system in the U.S. today work to promote the advancement of technology? I've got 3 arguments for and 3 arguments against it. The most common arguments for why the U.S. patent system works are that companies need to recover their research costs by being granted a monopoly for it. So I gave the example before. Pharmaceutical companies spend a lot of time, they spend millions of dollars to come up with certain chemical formulations to attempt to come up with a drug to help deal with the medical issue. If those companies did not have the guarantee that once they released their pill that it would be reverse engineered in a lab and someone would sell it at a much cheaper rate because that new person did not have all the development and R&D costs, then a lot of pharmaceutical companies wouldn't innovate and develop drugs. So this is probably by far the strongest argument for why the patent system works and should continue as it does. The second is to secure value of startups or investors. So if a software company or any startup launches with an idea, they often need investors in order to fund that company to where the company can mass produce the idea. And investors want to make sure that if they invest in a company, that someone else is not going to come and rip off the idea without any repercussions. And that's what patents do, is they protect the idea so that someone else won't come and rip it off. The third argument for the patent system is the bargain that I said the U.S. government strikes, which is that we need to promote people sharing ideas that they could have otherwise kept secret in the lab. So even if it's an engine that an electric engine, once you, by the patenting, the filing of the patent application for the electric engine, not only shows a picture of the engine itself, but also describes how it was made. So if you release something that you could look at, but you won't know how it's made, the patent system requires that the person who's granted the monopoly describe how they made the product so that other people can read how it was made and then later on build off of that knowledge in order to advance technology. The three arguments against the patent system are the cost of obtaining a patent is prohibitive. Like I said, it can range anywhere from $5,000 to $17,000. The cost of enforcing a patent is in the millions, so it's very expensive to enforce a patent these days. And an individual inventor, it's often difficult for them to go up against a big company in a patent infringement suit if the company has stolen the individual inventor's idea. They often they can hire attorneys on commission to do it, but otherwise it's very expensive to do so. I mentioned the weak examination of patents can grant weak patents and therefore monopolies to people who don't deserve it. And then finally, the idea of recuperating costs to bring an idea to market. For software, it's incredibly cheap. You can code an app at home using Apple or Google's software development kit and release it in their app stores, and it won't cost you much to bring that idea to market. So the idea that, at least with software, that it costs a lot of money to bring an idea to market like it does for pharmaceuticals, that often doesn't apply to the software industry. So I've got 4 minutes left. I'm going to go through this a little bit faster. Software patents are a special case. The way the software industry sees patents is they see it as a sword or shield. And what I often tell software engineers who are not for patents is that whether or not you like patents, patents do exist, and companies are using patents as a sword to assert patents against other companies or as a shield to shield themselves from patent assertions. Patents are in that way kind of like nuclear weapons, that a company that wants to survive in the marketplace, and particularly the software marketplace, needs patents that cover a technology so that if a competitor, and usually a dying competitor that's falling out of favor, if they come after a new up-and-comer in the marketplace with their older patents, then that up-and-comer has their own patents that they can assert against the competitor. You can see this in that Yahoo, when Facebook was going IPO, Yahoo asserted a bunch of patents against Facebook. I think Nokia has asserted them against Apple. So you see the companies that used to be the biggest deal in the world and that are no longer doing so, they have had their patents for the last less than 20 years. They now use their patents against the up-and-comers to obtain payments. And so patents are used as a defensive right there. Why software companies patent? 4 reasons: tech leadership, strategic positioning, defense, I mentioned, to defend against other patent lawsuits, and offense to obtain licensing revenues if they use their patent against other people. The average software company that goes IPO gains an additional $1.1 million in IPO value per patent they have. So that's attracting investment or strategic positioning in the industry. Famously, I think Microsoft supposedly earns $10 off of every Android phone that's sold, and that's because Microsoft has reached an agreement, I forgot with who, it might be with Google, because Microsoft had patents that covered Android technology supposedly, that Microsoft gets a cut in money of every Android phone that's sold. So that's considered offensive use. And then finally, the timeline for patenting, in case this is of any curious benefit, and I've done what we do here at my firm. It generally, the way that if you had an idea to patent and you worked at a company, you would usually submit your idea to your company's invention disclosure, to their legal counsel using what's called an invention disclosure form. Your company would usually evaluate the idea, and if they decide they want to pursue it, they would then set up a meeting with someone like me. So after I review your idea, I would sit down with you for an hour. I would ask you questions about your idea. A couple of weeks later, my team would draft a patent application. We would ask you as the inventor to make sure it's accurate based on our understanding of the technology. And then once you said it was accurate, and depending on your relationship with your company, you assign the rights to your company, which is its own area of contract law. The patent application is filed, and it takes, so that whole process is about 6 to 8 weeks from when you submit an idea to having a patent application filed with your typical patent attorney. or at least at McDermott. And then it takes between 1 to 3 years for a patent application to be examined and hopefully issue into an existing patent if you have something that's novel, non-obvious, eligible, and has utility, which are the 4 requirements. And that's my final slide. Thank you all for your time. I hope you found this helpful, and I'm available for questions now or later if you would like.
Well, I have to give up the room, so we're gonna wrap up. But I want to thank everybody who joined in. This was really, really useful. Now I can absolutely tell my husband, no, you cannot patent that idea that that you had. Every time he says I should patent that. And so, Asan, wonderful. Thank you. I knew it was going to be great, and it was. Just to let everyone know, tomorrow's our last day of Career Month, and we'll be hearing from Social Services Administration alumnus Quelly Quaza on the topic of nonprofit essentials, and I hope you'll participate. Thanks, everyone, and thanks, Asan.
Thank you.